Today's webinar will focus on how employers can help manage the impact of COVID-19 on their personnel. The challenge brought on by this crisis that's felt deeply by area employers, particularly those who have to make tough decisions, keep their businesses afloat. If you joined via the video link, you'll be able to follow along with the speaker slides. If you join by phone, the slides will be posted on the Chamber's website later this afternoon. Before we get to our speakers, I'd like to thank the sponsors of today's business support series. Expert Ready, Luxa Enterprises, Stride Bank, and Security Bank. And speaking of Security Bank, we are pleased to have with us Dawn Stafford, the President and CFO for Security Bank. I'll now pass it over to Dawn to introduce today's featured speakers. Dawn?
Thank you, Mike. It's an honor to join everyone today and introduce our speakers. First, Samantha Sierakowski Marshall is a trial lawyer with McAfee and Taft. She counsels and represents employers in all areas of labor and employment law. Also, Penny Horton is joining us. She's an HR consultant, blogger, and founder of Who's Your HR. Thank you both for joining us. I'll now let each of you share some of your tips and best practices for the workforce management, starting with Samantha.
Good morning, everyone. I hope you are doing well this Tuesday morning. I just wanted to take this opportunity to go kind of high level and give everyone sort of a reminder course on the basics of the Families First law, and we have some slides to go to walk us through that. I think at this point everyone is very familiar with the law, but I just want to kind of walk through this again high level. So if we could just go ahead and move on to the first slide. I think one of the most critical pieces here, and Penny is going to speak, I think, about this as well, is that we cannot look at this in isolation. We are not in a bubble. So while I think everyone is trying to be more forgiving of each other, and we hope that's from a legal perspective as well, there are a lot of other laws that come into play when you're trying to apply Families First or the CARES Act. And so you have to look at everything together cohesively. Not only the laws that are listed here on the slide, but other laws as well, including the WARN Act. One of the most key pieces of legislation that's playing with the Families First Act is the FLSA. As I'm sure, again, everyone's really familiar at this point with those considerations, looking at options for cutting costs presently. Moving on to the next slide, speaking specifically of the FLSA, you've probably already had these discussions internally, but if you have non-exempt employees, they don't have to be paid for the time that they're not working. That's not changed at all, of course, but one of the hiccups here is at least a lot of my clients have looked at going remote and looked at that as an option, which is recommended in a lot of circumstances. And so we have to be really careful with our employees that they understand that they have a responsibility there to manage all of their time and also document all of their time. I think one of my parting sentences to my own legal assistant was, write down everything you do. I want you to account for every minute that you're working. Exempt employees, generally they're going to be entitled to that full salary unless some of those narrow exemptions apply. Moving on to our next slide, as you know, we're past April 1 now. We know that the act became effective on that date, and quite frankly, as temporary rules keep coming out, we're still figuring out what everything means. But it applies to employers of all different sizes. It doesn't, you've got religious organizations, nonprofits, if you have less than 500 employees, the Families First Act's going to apply to you. And one of the pieces of that is, again, the Expanded Family and Medical Leave Act is going to capture employers that have fewer than 50 employees, which is a new component to the FMLA, if you will. But as again, I'm sure at this point everyone's very familiar with, we're providing for at this point paid sick leave and expanded FML under certain circumstances if it's connected to the coronavirus. Moving on to our next slide, specifically up to 80 hours of paid sick time for affected employees. And I think some people were confused about why with the FML you would get up to 12 weeks, where sick leave you would only have if you were actually sick yourself or caring for someone who's sick related to coronavirus, only get up to 80 hours of paid sick time. And I think the idea there is just that you have a 14-day quarantine, that's what's understood to be a safe amount of time. So if you are exposed, that's what you might need to take off from work. But if you have a child that's out of school, obviously that's an obligation that's going to continue for longer than the 80 hours. Moving on to our next slide. I won't read all of these categories on the slide, but again, as everyone I'm sure is very familiar, if there's a quarantine or isolation order, these employees are going to be covered by or possibly entitled to the paid sick leave, and that if they are a healthcare provider for someone else, if they're experiencing symptoms or they've been advised that they need to quarantine. So moving on to the next slide, I think we have the remainder of our category, which, the only other one that's sort of not captured there again is caring for a child, which really implicates both the family and medical leave and also the sick paid leave. So if we move to the next slide, the pay requirement here is 100% of an employee's regular wages for paid sick leave, up to $511 per day. If we're talking about paid leave to care for a child or to care for a family member, it's 2/3 of the employee's regular wages, up to $200 per day. Again, full-time employees receive up to 80 hours. Part-time employees are just, you have to average the numbers that they've been working over a 2-week period, and that will be the number of hours that they're entitled to. If we move on to the next slide, important things I think to just remember. I know all of you now have all of your posters, if you have the new poster up and provided all the notices, but make sure if you haven't done that, that you do. And probably the key piece, and this is going to be a reoccurring theme today, is that we need to document everything. Document everything you're doing and keep really sufficient records that are particularized. Don't require employees to find replacements to cover their time. Don't take disciplinary action or discriminate employees who take leave. Make sure you're doing everything across the board just as you would to adhere to the ADA, Title VII, all of that. All of those discrimination laws still apply. Moving on, and just to wrap this up, again, we talked a little bit about the expanded FML, but it's 12 weeks of job protected leave. A key piece for both of the sick paid leave and the expanded FML is just a reminder that if someone is able to remote work or telework, they're eligible for this paid sick leave. So just remember that when you're working out situations and trying to find an arrangement that's going to work for both the employee and for you. The first 10 days of the FML is unpaid, but then they may qualify for the paid sick leave. At some, they could actually possibly have the entire leave paid for. It's also cumulative, right? If you've already had an employee that's taken some of their 12 weeks, then you need to count all of that, and it all works together. They get a total of the 12 weeks in the relevant time period, the relevant 12 months. Okay, moving on. So this is what I'd like to just leave you with, as considerations, keeping employees engaged, keeping other laws in mind, consider what your ultimate goal is as far as if you're thinking about furloughing or laying off, how hard is it going to be to get those employees back to work, review all of your policies and your plans, and assess, the soft costs and the hard costs. And when you make decisions, please make them using legitimate business reason. And ending just real fast, if McAfee and Taft has a resource center that's available online, we're constantly adding to that material. So if you have questions, there's probably some sort of article or video alert there. Thank you very much for your time today.
Thank you, Samantha. Penny, let's go to you.
Okay, great. Thank you, Mike and Dawn and Samantha. Thanks for all of that great information. I'm going to talk a little bit about some of the options that employers have when they can't keep all of their employees working and busy. I know that a lot of the drivers behind that CARES Act is really to try and promote keeping employees employed as long as possible, right? And there's some funds that employers can get to help them do that. And Samantha touched on some of those things that we would need to consider as we go through those options. But if you do find yourself in a situation where you've got to make some really tough decisions, I want to at least touch on from a high level what you should consider in making those. So if we'll take a look at that first slide, some of the options that I have listed out are temporary reductions in pay, a temporary reducing of hours, and then mandatory paid time off and voluntary unpaid leave. So those are all options or triggers that an employer can pull to help reduce some of the cost. Now, there are a lot of considerations, and we won't go through kind of each of all of those, but they are listed out on the slide, some of the big things that you would need to consider as you do that. So as Samantha said, there are a lot of other rules that really come into play and other guidelines. So things like still maintaining minimum wage rates for your non-exempt employees is going to be important. If you do move someone from a full-time status to a part-time status, you need to understand what the implications are of that. And as an employer, what you're required to do and how that could impact other things like your classifications and exempt status on those kind of things. So, but they're out there, right? And those are options that you should explore and consider as you go through and look at what's going to be best for your individual business decision. On the next slide, I've got a few more options, which can include furloughs, right? Which is some portion of unpaid time off for employees. Being furloughed, you obviously have an opportunity to draw unemployment, and everyone's been hearing about this expanded pandemic unemployment assistance. And so that is something that we are looking for some additional guidance from the Department of Labor so that our own state can be rolling out those benefits, but there's going to be expanded benefits available for individuals through that. If you have to do a temporary facility shutdown, that is an option. And there are, again, an opportunity for people to draw unemployment benefits with that while you're temporarily shut down. And then layoffs and reductions in force, a lot of individuals will use those words kind of simultaneously or to mean the same thing. And they're slightly different. Typically a layoff is going to be where you do hope that they're going to be returning. So some sort of temporary termination of their employment. And sometimes you'll keep employees on their existing benefits while you do that. So again, a situation where you're going to need to review the specific plan documents that you have to make sense of what your employees would or wouldn't be eligible to do, but you can do a layoff by, department, by locations. They can be voluntary, they can be involuntary. Same with the reduction in force, which is really where you're eliminating a position altogether without an intent to rehire. In either of those cases, you need to make sure that you are making those decisions in a way that is based on business need and doesn't inadvertently discriminate against a particular group of individuals or a protected class. And then lastly, if you do have to permanently shut down your facility, there's obviously implications related to that, but one of the things that you'll make sure that you want to do is notify the state. And there's a termination form that you submit online when you're in that particular situation. So if we go to the next slide, in all of those decisions, right, and all of those options that I've talked about, you really need to go through and make sure that you as an employer understand all of those things that could potentially impact that or drive actions in other areas. So if you have collective bargaining agreements in place, you'll need to review those. If you have any sort of employment agreements with executives, severance agreements, some sort of deferred compensation plan, you'll have to look at that. Samantha already mentioned the WARN Act. So if there's a certain percentage of your workforce that you're going to let go, if it's large enough, it can trigger requirements under that WARN Act. Your existing policies are really important, and what they say about how you treat individuals and what you do with their benefits and different things when you're doing time off or furloughs or shutdowns, those kind of things. You got to review all of your benefit plan documents. Don't forget about COBRA. And you may have obligations to provide some sort of continued benefit coverage. And then, of course, Samantha touched on the Families First Response Act and some of the requirements as it pertains to that. If we look at our next slide, then one of the things that I know is always a question is if I have to reduce or eliminate positions or temporarily shut down, how do I keep individuals engaged, right? Existing employees that aren't being let go. And then also, how do I, once I return them to the workplace, right, if it's a temporary layoff, how do I keep those people engaged? And so there's really three keys to engagement. It's job connectivity, communication, and recognition. And if we go to the next slide, I've taken an opportunity and listed out under each one of those big bucket categories a lot of different ideas. And obviously we don't have time to go through those. But how you connect someone's job to the larger mission of the organization and make sure that they know where their impact lies. Be communicating and be transparent. You're probably going to have to increase the amount of frequency of your communications. Obviously, we're changing the way that we communicate with employees now. This virtual webinar is an example of that. And then I've listed out some rewards and recognition. So you can do fun things that are low cost or no cost in your organization. You can get creative, anything to just keep employees, involved and interactive in some way will go a long way to boosting all of your engagement within your organization. And I think that's it that I've got to share with you so far today. So thank you.
Penny and Samantha, thank you both. Excellent job. Great presentation. We've got about 8 or 9 minutes, maybe 10 minutes remaining. We won't have time for live questions, but we have some pre-submitted questions. And the first one is, if you have fewer than 50 employees and providing child care related paid sick leave and expanded family and medical leave, if those benefits would jeopardize the viability of your business, how can you take advantage of the small business exemption?
That's an excellent question. And I'm really glad that the question contemplated the fact that the exemption is only available for the child care component, because it's a very narrow exception. And there are basically 3 different prongs that would qualify an employer. Either it would, the small businesses expenses because of the leave and financial obligations would exceed the available business revenues and cause the small business to cease operating at minimal capacity, or basically that person's absence would just be a substantial risk to the financial health or operations of that business. And also, if you have a worker where they're key and there aren't sufficient other employees that could come in and do that job to allow that small business to operate at minimal capacity, that too may be an exception. So how do you get it, right? Well, there's no application, there's no submission process. This goes back to that document. You have to look carefully at these prongs, if you will, these guidelines that would allow you to have the exemption, and document why specifically it would apply to that person. It's an individualized case-by-case assessment. So you need to look at each individual and say, would this person's absence cause these things for my company or our company? And you need to explain, in good faith why that is, and keep those records for years. And I have to say, as sad as it is, right, I mean, we're going to see litigation out of it. I mean, people are going to sue. And in fact, there's already been some litigation that's arisen, not locally necessarily, but we just need to keep really excellent records.
Samantha, thanks. Penny, anything you want to add to that?
No, she summed that up really well, but I think it is that the documentation you'll hear that always from HR people and attorneys, right? Document.
Well, my next question for you ladies really is something that we've been asked a lot by many of our small business members, and that is, if we make some of our full-time employees move to part-time, are they then eligible for any unemployment benefits?
So that's a great question, and it does come up often. Under the Oklahoma Employment Security Commission guidelines, they consider anyone in Oklahoma who's working 32 hours a week or more a full-time employee. So if you have someone that you've moved to below 32 hours a week, then it is possible that they can be eligible for unemployment insurance. There is a formula, obviously, that the OESC uses in order to calculate the amount of benefits that someone is eligible to receive on a weekly basis. So when an individual that is working part-time enrolls and it sets themselves up to receive claims, then they are required on a weekly basis to report the amount that they are earning every week. And so if it's a situation where they're working, say, 20 hours a week now instead of 40, they would put in the amount that they are earning for the week, not when they get paid, but actually the week where they performed the work and therefore earned the income for that. They would put that in there, and then the unemployment office would take that essentially out of those calculations to make a determination about what they would receive from their unemployment benefits.
Okay. Anything, Samantha, you want to add to that?
Yeah, I think Penny summed it up. Again, excellent. She pretty much explained. I mean, so there's she walked us through that well. So I don't really have anything additional to add. Just that there's that opportunity out there to help your employees.
Great. My next question is, what are the requirements of the WARN Act, and how does a company know if that applies to them?
I'll let Samantha take that one because it can be complex for sure.
Yeah, this is a big question for just a few minutes, Mike.
Good luck.
Yeah. So
version.
Yeah, Penny touched, and brevity's not my strong suit. Penny touched upon this, right? That if you are letting go enough people that you could be triggering the WARN Act. So for employers that have 100 or more full-time employees, they may be subject to this. And there are different types of events that could cause the WARN Act to trigger, right? Closure of a facility, closure of an operating unit, a mass layoff, a temporary layoff, a reduction of hours, And each of those have pieces of specific numbers attached to them. You know, you have to give notice to your workforce, a 60-day notice to workforce. You have to give notice to certain officials in your community. And one of the questions that's been surfacing with our practice is, you know, there are exceptions to the WARN Act. And it doesn't mean that you don't have to give notice. It just means that your notice may be abbreviated or it may be delayed. So there's a faltering company exception that, you know, the jury's out whether it's going to apply in this COVID situation or not. But basically, if you're still, you're working to obtain capital or business and you're afraid that if you know, give notice that you're going to be letting these people go temporarily or permanently, that might interfere with your ability to do that, then you may be able to not apply with all the requirements of the WARN Act. You may be able to move forward without that full notice, particularly if it's going to allow you to stay open by not giving that notice. Also, unforeseeable business circumstances, and you know, this is hard. I mean, it seems like this might fit. You know, it's a sudden event. It's something that couldn't have been anticipated. It wasn't caused by our error. But you're going to be compared to what other employers are doing in your industry to see if more is going to apply or not. And so you just can't say a blanket statement, this is going to apply or this isn't going to apply. I think it's going to be a case by case and retrospective. The third is natural disaster, but I don't think that's going to apply here because it's not, I think that the case law suggests that it's more human error would not fall within a natural disaster. It's more like your tornadoes, your hurricanes, that kind of thing.
Thank you. Thank you so much, Samantha. We have time for one quick final question. I'll say quick responses. That is, if a company had to furlough or lay off employees before the Paycheck Protection Program was introduced, or they maybe became eligible, or maybe they applied, can they bring those employees back and utilize the PPP funds to pay them?
I'll hop in really fast, and maybe Penny, you can hop in too, but it's possible. It's possible. If you furloughed or laid off employees between February 15th and April 26th, and you restore those employees, it's actually full-time equivalents is what they're called, and there's some confusion about that. But if you restore those employees and their compensation by June 30th, then you might still be able to take advantage of that. This, however, is a completely moving target and it's evolving, and so every day we're getting new guidance. Penny, anything on that? I feel like I stole so much of your time.
No, you're fine. Those are very complex matters. So I think that's a situation where you work with your legal team and probably your finance team, right, to make that determination about how you do that and maneuver it, because it changes every day. So I wish I had a definite answer, but that's as good as it gets.
Yeah,
Well,
so
thank you, Samantha and Penny. I think Dawn would say that changing every day is certainly something that the financial institutions have been hearing a lot of in regard to the feedback from the SBA and from the Treasury and others in regard to many of these SBA lending programs. So thank you, ladies. You guys did a great job. Dawn, thank you for your engagement again. I'd like to thank Security Bank, Expert Ready, Luxor Enterprises, and Stride Bank for their support of this series. Anyone that called in late or joined us late, we'd be delighted to share this webinar, this call, along with the recording of the speaker slides. They'll be posted on our chamber website later this afternoon. Our next business support series webinar will be this Thursday, April the 16th, from 11 to 11:30. We'll be joined by Barbara Endell, a senior advisor for Jobs for the Future, and Sabrina Ware, Tulsa Works Director for Goodwill Industries of Tulsa. Barbara and Sabrina will focus on the future of work and will elaborate on the importance of developing new training partners and partnerships, reliable data, and a growing mindset to overcome these obstacles. You can register for that webinar on tulsachamber.com/events. In the meantime, if you have any questions, suggestions for our staff, please feel free to reach out to any of us. You can reach me directly on my cell phone at 918-409-1732, or you can email me at mikeneal@tulsachamber.com. We'll be delighted to get you to someone on our staff who'll be delighted to try to help you any way that we possibly can. And again, thanks to our speakers, our sponsors, and thank you all for joining us today. Have a great day, and we look forward to hopefully seeing many of you back on Thursday and again next Tuesday and Thursday. Have a great day.
Thank you.
Thank you.